Well, good morning. This is Jagender Rana here. So, the topic for the discussion today is passengers' liability in a private car. Passengers' liability in a private car. Insurance is a covenant of good faith where both parties are covenanted to abide by the terms and conditions of the policy. In the premises of an insurance company makes a deliberate attempt to escape the liability by introducing a copy of the policy other than the insured. Often the terms and conditions are being respected more in breach than observance. Insurance company has to bear in mind that they are trustee of the public and keeper of the public coffer. So often even genuine claims are being hotly contested in a routine manner by dragging the parties to court, wasting enormous time and money of the claimants to get their claim settled. They act like Motor Vehicle Act being a beneficial legislation aimed at quick redressal of the victims of accident arising out of the use of motor vehicles. A reading of the provisions of the Motor Vehicle Act 1988 and the rules framed thereunder, the provisions of the Insurance Act 1938, provisions of General Insurance Business Nationalization Act 1972, and the provisions of General Insurance Emergency Act 1971 makes it abundantly clear that every motor vehicle owner has to take out an insurance policy before using the motor vehicle in a public place. Thus, issuance of an insurance policy covering the risk for using the motor vehicle in a public place is a statutory duty cast on the insurance companies. The policies of insurance or certificate of insurance and cover notes issued by the companies in performance of their statutory duties can be classified as public document within the meaning of the Section 74 of the Evidence Act. So when certificate of insurance or policy issued by insurance company as a public document, as the same can be approved by production of a certified copy under Section 77 of the Indian Evidence Act. A certified copy of insurance policy produced by the insurance company is admissible in evidence without any formal proof of it. So with the overcrowding of Indian cities and an increase in the number of cars on roads, the possibility of accidents or mistakes has significantly increased. India reportedly has the highest number of road accidents in the world. The prime cause of accident is negligence and rash driving, and thus the law requires that the victim ought to be compensated for the loss suffered. So this is where third-party liability insurance comes into the picture. Third-party liability insurance is a cover that protects the owner, passengers or drivers from any legal claim or penalty made by the third party. The policyholder should know as to whose risk is being covered. It should be brought to his knowledge that even as family members would be gratuitous passengers traveling in this car. So the law governing the insurance policy ultimately is the law of contract, and so both parties should understand exactly what are the terms and contracts and for exactly what extent and what types of coverage the policyholder is paying premium. For the occupants of a private car are covered in terms of endorsement 5 to the policy, which reads as under that the accident to unnamed passengers other than the insured and as paid driver or cleaner private cars only in consideration of the payment of an additional premium. It is hereby understood and agreed that the company undertakes to pay compensation on the scale provided below for the bodily injury as hereinafter defined sustained by the passengers other than the insured and or paid driver, attendant, cleaner, paid, and a person in the and the person in the employ of the insured coming within the scope of the Workmen's Compensation Act 1923 and subsequent amendment to the said Act, and engaged in and upon the service of the insured at the time such injury is sustained while is mounting or dismounting from or travelling in the motor car and caused by the violent accidental external and visible means, which independently of any other cause shall within 3 calendar months of the occurrence of such injury result in. So it is evident from the above that while passengers travelling in a private car are covered against death or bodily injury resulting from the accident involving the vehicle, the insurance cover the insured is specifically excluded the insurance cover provided to the occupants. It's noteworthy does not follow from the provisions of section 147 of the Act. But on the contrary flows from the wider cover which the insured has secured beyond the minimum prescribed under section 147 by paying an additional premium. And in case the insured obtains such a wider cover under the terms of the policy, the insurance company will be liable to undertake the liability. So what is however clear, that is the liability of compensation, liability to compensate the occupant injured in any such event will flow not from the requirement of section 147 but on the terms of the policy issued on the insurer. So the private car policy offers following cover for any legal liability under the Motor Vehicle Act arising out of and use of the vehicle. What is covered? Legal protection for death or injury claims from third parties, including occupants of the car. What is not covered is damage to your personal property. Covered is legal protection for damage to third party property, personal accident benefits for owner and paid driver and occupants of car, protection for legal liability to paid drivers. So the coverage of private car policy says the insurer has to indemnify the insured in the event of an accident caused by or arising out of the use of the vehicle against all sums which the insured shall become legally liable to pay. As far as third party liability is concerned, the expression third party has not been defined in section 147. So what is the true meaning of the expression third party? A contract of insurance has two parties to it, the insurer and the insured. So these are the contracting parties of the contract of insurance, and they therefore can be called as the first party and the second party. Any party therefore who is not a contracting party to the policy of insurance will automatically be referred to and called as a third party because he is neither the first party, the insurer, nor the second party, the insured, or vice versa. So if one disease, the use of the word third party therefore in chapter 11 of the Motor Vehicle Act clearly refers to the intention of the legislature to point out to a party who is neither the first party nor the second party to a contract of insurance. Other than the contracting parties to the insurance policy, the expression third party include everyone, be it a person travelling in another vehicle, one walking on the road, or passengers in the vehicle itself, which is the subject matter of the insurance policy. So every insured takes out an insurance policy against a third party risk and enters into a contract with the insurer only with the motive, intention and purpose of covering the risk which may arise in relation to claims lodged against him by a third party. So the owner of the motor vehicle which is involved in the accident and who is insured by a policy of the insurance issued by the insurer is to be understood in the context of the expression third party under section 145G of the Motor Vehicle Act 1988, and as one including the owner of the vehicle also, and if so understood, the bodily injury suffered by him or even in respect of the death of the owner himself while being in the vehicle when the accident takes place, the insurance company is liable to reimburse a claim to compensate the bodily injury suffered by the insured or by the legal representatives on the death of an insured in such an accident. The insured person having not been expressly excluded from the definition of third party is as it occurs in Chapter 11 of the Act, the insured deemed to be included within the definition of the third party under Section 145G of the Act, and if so, even in respect of damage is payable as compensation to the insured or his legal representatives. The insurance company is liable to make good the claim. The liability of the insurance company is because of the statutory provision under section 147, 149, 150 and 150 of the Act it is claimed. As far as the owner of the vehicle is concerned, the National Insurance Company Limited versus Krishnan CMA number 3006 of 2012 Supreme Court, the appellant insurance company has disputed the manner of accident and the nature of injuries as the insured claimant himself was the owner of the Jeep. So the company has raised an objection as to how the claim petition can be maintained against himself when he is the insured of the offering vehicle. It was also contended that he cannot be treated as a third party. So on the principle that the insurance company has is vicariously liable, indemnify the liability of the owner of the vehicle only to the third parties and not to the owner himself. The company questioned the maintainability of the claim petition filed under Section 166 of the Motor Vehicle Act, read with Rule 3 of the Tamil Nadu Motor Vehicle Claims Tribunal. Without prejudice to the above, the appellate insurance company has disputed the nature of injuries, expenses incurred and the quantum of compensation claimed under more various heads. So the injured, being the owner cum insured, is not entitled to maintain a claim against himself under Section 166 of the Motor Vehicle Act for the reason that as per the principle of the insurance policy taken under Section 64 of the Insurance Act, the insurance company is vicariously liable only if the claim is made by a third party. So pointing out that at the time of accident the owner injured was only an occupant of the vehicle and not on his own wheels and not on his wheels. So learned counsel for the appellant insurance company further submitted that even if an additional premium was paid, that would not cover the owner of the vehicle who happened to be only an occupant to maintain a claim for compensation against himself, and further submitted that when there is a negligent act committed by his driver, the owner, being the occupant of the vehicle, cannot take advantage of an additional premium paid under IMT 15 and 16. For the gratuitous passenger in cars, the situation is different for him. Okay, the question as to whether gratuitous passengers traveling in a private car or pillion riders carried on two-wheelers are automatically covered under the package policy. Comprehensive policy came up also before the Madras High Court recently in a Royal Sundaram Insurance Company Limited versus VA, Meenakshi and others. This is 312 of 2009. So the division bench of the court, after observing the judgment of this court and various high courts on the subject, dismissing the appeal filed by the insurance company and in affirming the order of the tribunal awarding compensation of Rs 19.10 lakh to the legal representatives of the deceased passenger of the insured vehicle, held that it is clear from the act itself, the words of the policy and the decision of the Amritlal Sood case, that a comprehensive policy covers the risk of a gratuitous passenger. To the extent of the liability incurred, we may imagine what will happen in a case where the owner is driving his car covered by a comprehensive policy. He is accompanied by his wife and children. But there is an accident, as in this case. The wife and children are permanently disabled by the injuries. If we agree with the appellant insurance company, those pathetic claimants will not get any compensation. So the law never intended this to happen. That is why the TSA explicitly came out with the clarification, circular number 78. We cannot forget that the words used are third party and comprehensive, so we cannot deny this relief to the third party occupants in a car covered by comprehensive policy. Thank you very much.